Good afternoon, everybody. My name is Scott Sweatman. I'm a partner in the Vancouver office, Employment and Labour and Pension Benefits Compensation area. I'm your moderator for today, and you've joined, if you're on the line, you've joined Dentons Canada's COVID-19 Managing a Successful Return to Work for British Columbia webinar. Thank you all for joining us. Today's focus is specifically for BC employers, and we will be providing an overview of the current legal landscape, answers to some questions that we've already received, and ongoing questions as they come in. We know this continues to be an extremely challenging time. Every day seems to bring a new information, new questions. We want you to know that we're here to support you in any way we can, whether that's by keeping you informed, as we've been trying to do through various webinars, or being available to you offline to discuss specific situations that you may have. So please don't hesitate to call any of us that are on the website today. We'll certainly get back to you with as many quickly as we can. We have a lot to cover, so I won't spend much time on the introduction. But by way of housekeeping matters, once you've logged on to the webinar, you will be able to see the presenters' faces. So we're here via video, as well as the presentation slides that my partner Eleni Kasaris will be managing. Please remember, if you haven't already done so, to turn on your computer speakers. Hopefully you have by now. If you have any questions during the seminar, there is a Q&A button at the bottom of the screen that we'd ask you to put your questions in. I see we've received one already, and we will try to get to those questions at the end of the seminar. If we don't, we'll certainly keep them on and try to address them at subsequent seminars. Any technical questions you may have, you can also ask those in the Q&A box, and our IT specialist, who is standing by, will be able to assist you. One other bit of housekeeping: you should note the recording. Today's seminar is being recorded, and the slides will be made available probably early next week. I'm pleased today to introduce today's presenters, all of whom are in front of you on the slide. I'm going to start with my partner Eleni Kasaris. Eleni is a practice group leader in the Employment and Labour group in Dentons Vancouver office. She has extensive experience advising employers in all aspects of employment and labor law. A kind of fun fact about Eleni is everyone's been baking bread through this, or a lot of us have. Her fun fact is she's been making large batches of bread for her family before it was fashionable. So she's a fashion leader, if we want to put it that way. I next want to introduce my partner, Gillian Frank. As well as being our Chief Talent Officer, she's the Employment and Labour partner also in Vancouver. Employment, human rights, privacy, and occupational health and safety laws. Fun fact about Gillian, during her COVID stay at home, one of her hobbies has been to learn Clair de Lune and the piano in Bohemian Rhapsody. Good mix-up. She's teaching her daughter piano, and she's written 2 songs about her cats. So maybe she'll give you a free cat instruction later. Helen Park, I also want to introduce. She's my partner in the area of immigration law and business immigration for corporate clients and businesses in Canada, the United States, and worldwide. You're in very good hands with her on the immigration side. Fun fact about Helen: she loves to knit. She once tried at the office, I didn't know this, to start a knit club at the firm, which was met with great enthusiasm. All the lawyers attended. They brought their knitting needles and yarn to the club meetings and watched her knit the sweater while they drank wine. So good luck with that knitting club. And 2 of our, not to be outdone, the 2 of our senior associates in Employment and Labour are also with us today, Jeff Bastian and Taylor Buckley. Fun fact about Jeff: Jeff rode his bike, and I'd forgotten about this story, but reminded of it as I was reading about it, all the way across Canada a number of years ago, all the way across Canada. Almost as impressive, he managed to do so the whole trip without a flat tire. I don't know what you avoided, but he did a good job of that. Fun fact about my colleague, Taylor Buckley, who also works in the employment and labor area, as well as pensions, benefits, and compensation. Taylor spent over 200 days canoeing in the Northern Ontario area. So we're an eclectic group. So without further ado, let's get started. And I'm going to turn it over to Eleni Kasaris. Eleni?
Thanks, Scott. You may hear my son crying right now, and I apologize for that, but that's a pre-nap usual occurrence in the pandemic time, so he should be napping soon. I apologize for any background noise. We're going to start off by going through some health and safety requirements relating to return to work, and we're going to start, although there's been specific guidelines published, and Jeff will be going through those relating to your COVID-19 safety plan and things you need to know about that. I'm going to start with the basics. And when all of this started, WorkSafe BC did publish some guidelines. They weren't particularly extensive. They wanted to make sure that people understood that basically WorkSafe laws, the Workers' Compensation Act, Occupational Health and Safety Regulation, continues to apply during the pandemic, and that following the provincial health officer's orders and guidance represents basically the minimum standards. So we're all familiar with WorkSafe BC and how they like to shift the burden of compliance to the employer. So from the beginning, it's been on the employer to come to terms and come to grips with how to create a safe workplace. Now, following the provincial health officer's guidance did involve having a number of your staff, if not all of your staff, depending on your business, work at home. And WorkSafe on March 19th did publish a guideline relating to health and safety responsibilities when working from home. And these guidelines, if you were to go into the link when you get the slides and read them, are not what you would call particularly helpful in terms of how you establish your policies and procedures for work from home, but they do outline what the basic requirements are. So employees are expected, and if you haven't been thinking about health and safety at home, you should, because WorkSafe suggests that you should and says that you should. Employees are supposed to conduct an assessment of their workplace and report any hazards to their manager, just like they would if they were in the physical location of the workplace as opposed to working remotely. There should be protocols for evacuating the home or temporary workplace to a safe location if needed, and how to contact the employer in case of emergency. And there should be discussion as between the workers and the employer regarding workplace practices and how to report work-related incidents or injuries, as well as a discussion of ergonomic considerations. So while WorkSafe in this guideline has listed the high points of things employers should do, they haven't provided a lot of guidance on how you should do them. Rather, the actual gist is that your home office is right now, at least while people are working from home extensively, an extension of the workplace, and the regular health and safety laws apply equally at home as they do in traditional workplaces, including reporting injuries and training and implementing policies and procedures. How do you do that? You do that in the same manner that you've done it for your workplace, but just translate that to the home. And unfortunately, everything happened so quickly, many employers did lose sight of whether or not they have health and safety obligations at home for their workers. And the ergonomic piece, I think, is especially interesting for many employers, and what the costs are associated with that. And there is some guidance on the WorkSafe website relating to ergonomics, which should be considered by each employer as well. So another thing that applies as equally in the workplace as it does at home is the duty to report injury. So it's always been the case that if there's occupational disease or injury in the workplace, you're supposed to report it to WorkSafe BC within 3 days. WorkSafe does want to avoid the flood of claims related to COVID-19 when COVID-19 diagnosis or contraction of COVID-19 is unrelated to work. So they've published in one of their FAQs basically a test that they'll apply, and that is evidence that the worker actually has COVID-19, and then that the nature of the worker's employment created a risk of contracting the disease significantly greater than the ordinary exposure risk of the public at large. And that requirement in the FAQ, they give the example of the healthcare worker. A frontline healthcare worker has a greater risk of contracting COVID-19 at work than if they were in a different occupation and had the sort of regular community exposure that we all have. That being said, this is more about whether WorkSafe will cover a claim and costs of that claim, as opposed to, I think, putting on the employer a big responsibility to figure this out perfectly before reporting. So I would say that a best practice is, if you're not sure how your employee contracted COVID-19 and you think it might be workplace related, you can file a Form 7 injury report and let WorkSafe sort it out as to whether the claim is compensable or not. It's also often advisable to report to the local public health unit. That being said, there's no requirement to do so. And if your employee has been diagnosed with COVID-19 and took a test, the public health unit will know that and will take the steps it needs to take. So working from home, a few additional considerations. These are not related to health and safety, and they are probably the things you've been focused on more since working from home started as a more prominent aspect of everybody's work life. And that is your data and is your confidential information secure at home? What are the terms and conditions of employment now that your employee is working from home? Are they now thinking more along the lines of, this can be permanent, I can work from home forever? So it is important to revisit your confidentiality and technology policies, remind employees of their duties and obligations. Working from home is not a license to start forwarding information to their personal email accounts. Similarly, you want to make sure you have steps in place that workers can follow respecting destruction of records or return of records. You don't want them putting things they've printed on their home computer in the regular recycling box that goes in the back alley once a week. You want to make sure that there's a protocol in place for destroying that information so it's not leaked. In terms of their terms and conditions of employment, we have been getting questions about, can employees expect to work from home permanently? What can I do about this? And, do I care where they're working? That was a question I've had more than once in the last week, because some people are stuck in other jurisdictions. And you really have to think about, as an employer, what you want to see the workplace be down the road. Are you happy with a combo of work from home and working in the office? Do you want to make sure that it's clearly communicated to your employees that the working from home arrangements are temporary, or will you offer it on a more permanent basis? If someone's working outside of the country, what laws apply to their employment? Do the laws change? Because I can tell you that if you have an employee working here in BC, but they're from somewhere else and should be in your office in Ontario, BC Employment Standards Act, the branch will say that the act applies to them here in terms of hours of work, overtime, etc. And that's another thing to keep in mind. You should have policies, formulated for working from home, reminding your employees of the same things that apply in the physical workplace, which is, you're not allowed to work overtime unless your manager approves it, and other checks and balances to make sure that the laws that apply to them and equally apply to them at home continue to be enforced by the employer, even though you're in this awkward or more difficult relationship than you had before with a majority of your people who are stuck at home or voluntarily at home. And with that, I will turn it over to Jeff, who will talk about the COVID-19 safety plan and other requirements.
Thanks, Lenny.
Lenny.
So I'm just going to touch on the COVID-19 safety plan, which if anybody's been listening to Dr. Bonnie Henry's briefings, you've probably heard about. And so basically, in connection with British Columbia's restart plan, the provincial health officer has ordered that employers develop and post a COVID-19 safety plan, both at the workplace and if the company has a website, on their website as well. The plan must outline policies, guidelines, and procedures that the employers put in place to reduce the risk of COVID-19 transmission. And the safety plan follows 6 steps that I'll talk about on the following slides that outline how to return to safe operation. But before moving on to the next slide, this graphic on screen right now from WorkSafe shows how the types of protection protocols should be considered sort of in sequence. Essentially, measures that avoid or eliminate risks altogether should be the first option or line of defense. And then as further protection, engineering controls, such as physical barriers, should be considered. And then next down the triangle there, employers should consider administrative controls. And these generally deal with how space is used or accessed. And then finally, if the first three levels of protection are not sufficient to control the risk, employers should consider using personal protective equipment such as non-medical masks, and that's the red square at the bottom there. So on the next slide, I set out the 6-step process that WorkSafe has developed, and this is there's more information available. There's a more fulsome guide on WorkSafe's website. There's a link there to that. And basically the 6 steps are as follows. The starting point is to assess the risks of your workplace. And so WorkSafe has said that the Joint Occupational Health and Safety Committee should be involved in that process. There should be a walkthrough of the workplace to consider risks. For smaller workplaces without an OHS committee, a worker health and safety representative should participate in that. Next, employers need to implement protocols to reduce the risks identified. Some protocols will be applicable to most businesses, and then there are others that are probably going to be a bit more industry specific. And WorkSafe BC has posted guidance documents for certain types of industries and businesses, which I'll get into. Third, if you haven't already done so, you need to develop policies that relate to minimizing COVID-19 risks. And so these might include policies such as who can attend or not attend the office or the workplace. So anybody that's ill or exhibiting symptoms should not be attending, as well as expectations or requirements of visitors, what to do if somebody feels unwell while at work, and those types of things. Fourth, employers need to make sure that these policies are actually communicated to employees, and that employees are trained regarding the policies and procedures so that they're aware of them. And then fifth, employers should continue to monitor the plan and update it as necessary and as guidance and direction from the provincial health officer evolves. The last step there, the 6th step, is to address any risks that may arise from resuming operations. I think this is really probably part of number 1, but it's more aimed at things like, are there is there machinery that's not been used for many months that needs to be serviced before trying to restart it? Does that present a safety risk of resuming without servicing things properly? So on the next set of slides, just touching on some of the specific types of risk reduction protocols that you might consider. These are fairly general ones, and I won't go into detail on each of them, but these types of things are just suggestions that may help either ensure that there's physical distancing in the workplace or avoid people coming into contact with each other unnecessarily. So things like having designated entry and exit doors or up and down staircases to reduce the passing of people in the hallways, that sort of thing is something that would apply to most workplaces. On the next slide, it's just a continuation of these kinds of considerations. So you might consider whether visitors or customers, if they do need to attend in person, how to deal with that. If you can ideally pre-arrange meetings and that sort of things so that visitors and customers are aware of what precautions you're expecting them to take, that's best. And sort of a tricky thing to navigate is the use of elevators in office buildings, because that's something that's going to be a challenge for especially big buildings to deal with, how to limit occupancy and keep people apart on elevators. So on the next slide, I include a link there to WorkSafe's industry-specific risk reduction protocols that may also be appropriate. So there is a list, and I have it on the next set of slides, about sort of certain industries and businesses that have considerations that you would want to be aware of. You may also consider if your business has professional or industry association. They may have provided commentary on recommended best practices, and that's often a good source because that can result from several businesses brainstorming solutions and protections. Additionally, the BC Centre for Disease Control has developed guidance for certain types of businesses, such as grocery stores and restaurants. So that's also another resource to be aware of. So this is just a list. There are sort of the two phases to BC reopening. These are available on WorkSafe's website. They have guidance for each of them. A lot of it's fairly general, but there are some very specific types of recommendations. Like, for example, for servers at restaurants, the recommendation that rather than reaching across a table at a booth, that they put the food at the front of the table and allow the customers to distribute it, those types of things. So if any of your industries or businesses are included in this list, I'd recommend having a look at WorkSafe's website to see what they have to say. With that, I'll pass it over to Taylor to talk about some privacy considerations.
Thanks, Jeff. So I'm here to talk about employee privacy specifically. There are a lot of privacy related issues that might involve your customers and clients as well, but we're focused on employee issues here, and the principles, however, will be the same for all of them. But in light of some of the enhanced screening procedures that you might be thinking about putting in place or have in place, those are inherently going to result in more personal information collected about people. So you need to just be aware of your obligations around that and how to manage those. So I'm going to talk about what those general principles are. They remain unchanged largely from despite the COVID pandemic. Some practical steps to manage and approach those and your obligations in dealing with those personal information issues, and then a couple of specific scenarios that might come up. So the Federal Privacy Commissioner has been working with the other privacy commissioners in every province to come up with some guidance around, privacy in the global pandemic. The principles remain the same, but the principles are flexible to individual circumstances. So there has been recognized the need that, there might be reason to apply privacy rules slightly differently in this context while it persists than the ordinary context. But generally, organizations can collect, use, and disclose information about their employees only with meaningful consent, which means the employees know what's being collected, how it's being used, who it's being disclosed to. For employees specifically, in relation to information that's used to manage their employment relationship, their date of birth, maybe information about enrolling them in benefits, you'll need to give them in BC consent that you're going to be doing that. There's a special carve out. So once you have the information, and consent isn't enough, the purpose of collection has to be reasonable as well. You can't just get consent to collect anything and everything for every purpose. The purpose has to be justifiable. Once you have the information, you need to protect it. And that means appropriate safeguards to protect the information. So from locking cabinets to restricting password protected access, to restricting who can access, to contractual obligations by your service providers. So what is reasonable depends on what you have and how you're using it. So things like health information, which we'll talk about in a bit, are more sensitive than other pieces of information. So on to the next slide, we're going to talk a bit about what you need to think about, what you should be thinking about before you implement any kind of screening procedures, which is the focus of what we're going to be talking about a lot. So a privacy impact assessment is a concept under the privacy legislation that is basically an organization taking a step back, thinking through the privacy issues related to a proposed course of action and figuring out how to mitigate them. It's required for some public bodies. It's best practice for non-public bodies. So things like thinking about what you need, why you need it, and then designing processes to keep that information safe. On the next slide, once you have your plan in place and you know what you're going to collect, what you're going to do, let people know what you're doing, get their consent if you need it, be open with them, and tell them how you're going to protect their information, all of that good stuff. And then once you have the information, make sure it's hived off, make sure it's only seen by whoever needs to see it, things like that. So these are some ways to manage those privacy risks once you have the information. And once you don't need the information anymore, get rid of it. It is not good to have more personal information than you need. And in fact, it is a breach of the privacy legislation. So it is best practice to be regularly checking or having, schedules for how long you'll keep information. On to the next slide. We're going to talk about some specific issues, kind of an increasing sensitivity of information. Now, the first one is what's called active screening, which is what you've probably have experienced in your day-to-day at this point. So have you exhibited any symptoms? Have you, it was travel early on, things like that. That is a collection of personal information, even if the information isn't kept, even if it's just a check the boxes before letting people in, that is a collection. So you need to consider that, how you're going to carry that out. It's currently recommended by public health authorities, so it's probably a reasonable collection at that point. The next step is temperature and thermal screening, which is something we've been getting a lot of questions about, is can I take the temperature of people entering my premises? In the ordinary sense, it's generally not allowed, you're not generally allowed to just collect health information. It's sensitive information. You need to be very careful with it. It may be justifiable in this circumstance. Again, this is all very workplace specific, but there is an occupational health and safety obligation that employers have to provide a safe workspace. And if, for instance, you are dealing with vulnerable populations, you may be more justified in temperature screening. But if you do go ahead with it, consider things like you should hire somebody like a professional, a nurse, to administer the screening. Be careful about what records you collect and not collecting more information. Collect the information, do the screening out of sight, so it's not an invasive process. And keep in mind that there might be other reasons for someone to have an elevated temperature, either a health reason, which you want to be careful collecting too much information about for human rights reasons, or it could be as simple as someone just ran in from their car. So always have a medical justification for any information you're collecting of a medical nature, and have the reasoning to back that up. You need to be able to justify all these collections. On to the next slide, I want to talk a bit about biometric identifiers. So part of managing COVID in the workplace is tracking who's in the workplace. So biometric scanners, fingerprints, retinal scans, facial recognition. This again is sensitive personal information about people. And so you should be getting express consent to get it, and that can be by your process, by somebody ticking a box, or good signage for thermal screening, for instance, where you're not taking someone's temperature with a thermometer. But be very careful with it. This is a developing area of the law, and the standards are getting higher for making sure that people's personal information is not being abused, collected or kept or not protected. So recommend thinking of other less privacy, whether there's a less privacy invasive way or of identifying people who are in the office. That ties in nicely to contact tracing. So the bullet points on this slide address contact tracing apps. Contact tracing itself is simply the process of identifying someone who's been exposed to COVID in this case, and tracing back who they've been in contact with for the purpose of tracking the contagion. And so that is also a collection of personal information. It's something that you need to disclose, again, what the information is being used for, and do it in a way where you're protecting people's identities as much as you can. And we'll touch on that in a little more detail later on in the Q&A section. But contact tracing apps is where the phone's, for instance, Bluetooth capabilities are used to keep a log of everyone that's been within 2 meters of every phone that's been within 2 meters of that phone. And then that information becomes unlocked when someone reports that they have symptoms or been in contact, and it automatically notifies people. So great piece of technology, but obviously a lot of privacy concerns. So the Privacy Commissioner has listed, things to consider, mostly for governments, specifically for governments, but it's a good list to keep in mind for these apps. And so if you're thinking about people requiring your employees to have such an app, or requiring them to have an app, not a specific one, you should let them know the risks associated. If you're going to be using a specific app, you should be aware of what that app is collecting, how it's using that information, and what security measures are in place. And you should have contractual agreements with respect to protecting that information. So it may sound great to use these apps, and it is, but you've got to make sure you do your due diligence and that you are informing employees of all the risks and how they're using that information, because ultimately the employer will be responsible. On to the next slide, employee monitoring. So this has more to do with employees are working from home. They're not under the direct supervision of their usual managers. There might be some interest in tracking productivity, other ways of managing employees when they're at home and you're not in the same place. So there's lots of software out there, but again, you've got to be careful. So there have been some cases about this specific issue outside of the COVID context, but the general principle is that, again, blanket real-time tracking and monitoring of your employees is going to put you outside of the privacy legislation. So first things first, employees should know exactly what programs are being used, what's being collected, how it's being used. Being open is key about this stuff. Avoid collecting more than is necessary. For things like real-time collection or screen capturing, those should only be used as part of an investigation where there's already a flag or something worth investigating. And make sure the people who are carrying out any tracking are aware of the privacy obligations, they're trained not just in how to use the software, but the privacy issues that are associated with it. And then again, always think about whether it's effective, whether it's necessary, whether there's another way to do the same thing. And this kind of ties in similarly with all of the remote technology you might be using. You should understand what information it's collecting about your employees. And understand what the security risks associated with them are. So whether it's, meeting platforms or chat functionality or even analog issues getting outside of the employee context, but maybe client customer information where people are maybe bringing information to and from work where they wouldn't otherwise be doing it. You need to think about the privacy impacts of your new working reality. So I think that's all I had planned for now on that, and I will pass it off. Thank you.
So we're going to move on to some frequently asked questions. These are questions that we've been receiving both just in our daily lives and questions from other webinars. I'm going to turn it over to Gillian Frank to address the first question. Gillian? And the question is, what screening should I do of employees and customers? Can I check temperatures? That was dealt with a bit by Taylor. And does everyone have to wear masks? So there's sort of a combination of questions with a similar theme. Gillian.
Thanks, Scott. So Taylor has talked about this. Jeff touched on it a bit as well. I think from a legal perspective, the answer is somewhat straightforward in the sense of there's no legal requirement to do any of the temperature screening that we've talked about. There's no specific legal requirement from WorkSafe BC for people to wear masks. But when I put on my hat as a Chief Talent Officer, I think this question isn't just about the risks or can I do it, it's what should I do? And what questions should I ask myself when I think about the type of screening that I need to do as we start bringing people back to the workplace. So I'm going to focus on that more so than the specific legal requirements, which I think were really covered off well by Jeff and Taylor and Eleni. So, from a legal perspective, you think about what's a reasonable safety measure. You have to think about all the risk issues with respect to privacy. When you think about actually doing it, the questions that I have been asking myself with respect to our workplace, first, is there close and prolonged contact between employees at the workplace? So by close, we mean within 2 meters, and prolonged, we mean, say, more than 15 minutes, or at least that's the medical advice that we've gotten from the advisors that we use. So when I think about that, that's sort of a first check of, if that's happening and there is that close and prolonged contact, then what do I need to take? What steps do I need to take? And is that going to include screening? So when I think about our office, if we can limit the number of people that are in the office, then we probably don't have close and prolonged contact between people. But the more people that we have coming into the office, the closer people have to work together, the more contact they'll have. And then I may need to take further steps to make sure that people are protected. And that could include health screening questions. It could include temperature checks. It could include masks. So after that question, I'd ask myself, what do we need to do, not necessarily from a health and safety perspective, but as an assurance measure? So when I've talked to a number of other people in similar talent positions, we thought about it not so much as is this actually going to tell us whether somebody is at risk of contacting COVID-19, but should we be doing and taking some of these steps like screening to assure employees and customers or clients that we have exercised our due diligence and that we're demonstrating that we have a safe workplace. So with respect to temperature screening, for example, our global security, the person in charge of our global security team has said, it's like going to an airport. Temperature screening isn't actually going to tell you whether or not someone has COVID-19. As Taylor referenced, there's lots of reasons that someone might have an elevated temperature, but it can provide the assurance or the appearance that you are taking steps to screen people, and that might give people more comfort to come to your workplace. And that's really a lens, I think, that's important to think about. In terms of an assurance measure, I think the more you listen to what the health authorities are saying, you listen to what your industry is doing, and then you have to make a decision about whether that's a step that you should take to provide that assurance to your employees or clients. So is it something they're going to expect? When I've looked into it, I know that no law firms in Canada or in the US so far have started to do temperature screening. I know it's very common in our Asian offices to do temperature screening. And when we were saying in a recent global call, there's no way in Canada that we're going to do temperature screening, we got good advice from one of our offices in South Korea to say, things change all the time. The only thing that we know is to expect the unexpected. So 2 months ago, our health authorities were telling us that no one needs to wear masks, it's not necessary, and now that's completely changed. So even if right now we don't think we're going to check temperatures, maybe it's something we need to consider if that's something that employees are going to expect to feel more safe coming into the office. Maybe that's something our clients are going to expect. So while we may not do it now, we still need to think about whether that's something our industry is going to do broadly, and we need to be prepared for that, or whether that's something sort of in Canadian society that will become more normal, and we need to be prepared for that. One of the next factors that I think about is how disruptive is this type of screening going to be to our employees, to our clients. So it's not just about whether we can do it, but really whether we should do it. Is that going to make people want to come into the office? Is that going to make them more fearful of coming in? Where does that balance land? So when I think about temperature screening, for example, if people are going to first stand in line to wait for an elevator and then come up to our office and stand in line to get their temperature checked, how much of their day have they just lost? And how productive are they if we're going through all of these screening requirements? So that's a factor that I've taken into account in thinking about whether that's the best approach or not. One of the next questions that I've asked myself is, how's this going to work? So from a mask perspective, who provides the masks? How many masks do people need each day? The cost of masks right now is astronomical because there's a huge demand for it. And all of that, I think, needs to be taken into account and balanced against what kind of close and prolonged contact do people have, and what assurance measures do you need to give people. I know the approach that we're looking at right now is to say, if there's someone who's required to be in our office because they're performing a core necessary, essential part of our business, we will supply them with masks. but if someone's voluntarily coming in, they're required to provide their own mask. We've received notification from our landlord that masks are required when people go into elevators. So in that circumstance, we do have to notify people that before they come into the office, they're going to have to wear a mask. So there's a lot of factors in terms of how's that actually going to work that you have to take into account before you take these steps. In terms of temperature screening, I'd said earlier that, well, we're not planning to do that right now. We want to be prepared for it in case that becomes a more normal requirement in Canada. So we think about who would do that screening. Is that a receptionist? Is it an office service employee? Are they prepared to do that? And how are we arming them with the right information to ensure that privacy regulations are complied with? That to me seems pretty overwhelming to impose on employees who really would not have that kind of responsibility in their jobs in the past. So another option is to get a nurse practitioner to come into the office and do that screening every day. And that's something that we've looked into further, and it is an option. There's a number of companies that provide that service. I think in terms of privacy requirements and best practice, ensuring that you're keeping distance and that the testing itself isn't causing more close and prolonged contact than you need. I feel more comfortable having a nurse practitioner do that work, similar to when we have a flu clinic in our office, that we would have a nurse practitioner do that kind of work. So that's something I throw out there as a consideration when you're looking at screening or temperature checking. The last question that I ask, which I think is an important question to ask, is whether there's another way beyond really somewhat invasive screening that you can achieve the same result. So, I go back to close and prolonged contact. Is there a way that I can limit the number of people that are in our workplace so that they don't have close and prolonged contact? When I was thinking about that, I was thinking of how do we limit the number of people that are in our office? How productive are people working remotely versus in the office? And we did a remote work survey and found out that 96% of our people say that they are as or more productive working at home as in the office. So if that's the case, then there's no immediate urgency for us to go back, and we can take a more cautious approach to limiting the return to work to 20% of people. If that works, then 40% of people, and then moving on from there and taking more of a measured approach to how people return. I did get a question before the seminar about sharing a survey and if we had any suggestions on employee survey. When I wear my hat as Chief Talent Officer, I'm happy to share that information or what information that I have about the survey. So feel free to reach out to me after the seminar and we can chat further about employee surveys. So those are the factors that I would take into account. I think, ultimately, there's not an easy answer to this question. I think you have to take into account a balance between how to operate your business productively and efficiently, and how to maintain safety and assurance of safety to your employees and clients. So hopefully they're helpful to you. And of course, we're happy to take questions.
Thank you, Jillian. I'm going to turn it over, another question to Helen Park. The question is, what can I do to get my foreign workers into the country? Helen?
Okay, so this is a loaded question. How do we get people into the country when they've closed the borders? So it's been a challenging time. I think there have been numerous orders in council which have been written and published mostly with respect to the Quarantine Act as opposed to the Immigration Refugee Protection Act and regulations. So it's been challenging to kind of get through all of the different regulations that we are now having to look at before we can figure out how we can possibly bring some foreign workers into Canada. So what has been clarified over the last even last week is that really it depends on, number one, where your foreign worker is currently located. So the first thing to look at is, are they in the US? And ironically, if you are in the US, which I think is the kind of largest number of COVID cases in the world, but if you are in the US, there is a easier mechanism in place so you can come to Canada to apply for your work permit. So if you have no symptoms of COVID and you are coming from the US, you are visa exempt, and you wish to apply for a work permit, you can seek to enter Canada as long as you can show that your entry to Canada is non-optional and non-discretionary. So what does that mean? So that means there's a bit of a test that they do at the border. They need to see you have a valid job offer, that the work is, they were using the word, quote, essential. They've gone away from that because there's so much confusion, but they want to see that the entry is necessary, that you are coming for legitimate work, that the work is ongoing, that your job hasn't disappeared or the business has not closed down due to COVID. They want to ensure that if they let you into Canada and issue that work permit, that you have work lined up. Another requirement is a 14-day quarantine plan. It must be written out and officers are looking at it. And in fact, RCMP officers across Canada and health authorities across Canada are doing checks, random checks of foreign workers coming into Canada to ensure that they are quarantined. And there are huge fines if they find that you are not meeting the quarantine requirements. And what I've suggested to clients for their 14-day quarantine plan is to write out exactly the location, address of where they're going to be, how they're going to get from, if it's not a land crossing, if it's coming in by air, how are you going to get from the airport to the accommodations? How are you going to get groceries? So have you ordered groceries online? If you're here in the Lower Mainland, it's difficult to get groceries quickly delivered because of the demand. Myself, we were trying to get groceries delivered. It takes a couple weeks. So you have to make sure that you've got maybe a colleague or a friend or somebody who can help you with that. And finally, a contact, emergency contact. I would have included in the quarantine plan somebody who you can contact and CBSA can contact or RCMP can contact if they can't find you. So have that written and in place to provide to the officer. So everybody else, so everyone else who needs to come or wants to come to Canada who is not in the US, it's a bit more challenging. So first of all, you need to either have a valid work permit, so one that was issued prior to COVID, or one that has been applied for through the visa office. So if you've applied online and received an approval letter, it's called a letter of introduction by the visa office for a work permit, you may now be able to come to the port of entry, whether it's land or air, prove that the entry is for a non-discretionary purpose, and at that time be issued a work permit. I warn you, the visa office applications are delayed. Most of them are delayed because of biometrics. You need to go get your fingerprinting and photos taken by a visa application center. But of course, all the visa application centers are closed in most of the world. I understand that there are some openings in Asia now, China and Vietnam. Certain places have opened their visa application centers. But for the most part, like in the US, Europe, South America, they're all closed. So even if you apply online for a work permit, you're getting stalled by that requirement. So for those folks, I mean, we're just gonna have to wait. We're gonna have to wait to see how they're gonna deal with biometrics. Right now, the borders are closed until June 30th. There may be further orders in place to alleviate certain occupations, as an example. If you are providing essential services, so if you have a foreign worker who is coming in to provide medical or emergency services, if you're a truck driver, if you're in the infrastructure industry, you might be able to come in and apply for your work permit, for entry, not necessarily a work permit, but authorization, for example, as a business visitor on the spot. Now, I warn clients to use that particular category sparingly. It is an onerous test that they are applying at the border. It's one thing if you're a truck driver coming back and forth and making deliveries, but if you are coming and you're, you know, a software engineer that works for an infrastructure company, they're going to look at you and say, well, have you been working remotely all this time? Like, why is it suddenly essential that you come to Canada? So they're going to be applying all sorts of tests, and you want to be sure that if you're going to try for that category, that you have a lot of backup paperwork and evidence. And again, you must have that 14-day quarantine plan. I know we're running out of time, so there are some exemptions from the quarantine requirement. I've listed a few there. Again, we can apply in advance to the Public Health Authority. They have now been inundated by these requests. So it's used to be, you know, within a few days. It seems to be taking longer than a week now to get these opinions back. So if you don't fit nicely in one of these exemptions, I would recommend that, you know, you think long and hard before you try to send someone across the border. One other final thing I wanted to point out that a lot of employers might be interested in is that there is now a new expedited change of employer process for those foreign workers who are working for one employer, may have lost their job due to COVID for whatever reason, and they have found employment with another employer and they need to switch their work permit categories. Typically, the online inland applications are 2 to 3 months. What they're now providing for is as long as you meet the requirements to switch the employer, for example, you have a new LMIA application, or if you're under a NAFTA professional category and you can you know, switch from one employer to another employer fairly easily with the employer portal filing, then you can submit your application and then write to Immigration Canada to request a change of employer before the new work permit is issued. So it's something that they've only put in place because of the COVID situation, and it's something that is certainly helping employers meet, you know, their requirements with various foreign workers and foreign workers to keep employed during this difficult time. There's lots to talk about with regards to immigration. So if you do have any questions, please feel free to reach out to me, and hopefully we can provide some assistance.
Thank you, Helen. That was terrific. We're going to move on. We're a little short of time to Jeff. Jeff, the question is, how do I manage refusals to return to the workplace? Do I have a duty to accommodate? What if the employees are not following COVID-19 protocols? Jeff.
Thanks, Scott. So these are somewhat related, so I'll address them all and sort of turn to the third one at the end. But these are questions that we've been seeing quite frequently over the last few months. And in dealing with these types of issues, it's important to keep in mind that nothing has really changed from a legal perspective. It's really a matter of applying existing laws and regulations to a new set of circumstances. And so to that end, occupational health and safety regulations continue to apply, as Emily mentioned. The Human Rights Code, which prohibits discrimination in employment based on protected characteristics, also continues to apply. So as a starting point, employees may refuse to work if they have reasonable cause to believe that it presents an undue hazard. So what does that mean? Not just any belief that the workplace represents a risk is sufficient for a refusal. There must be an objective basis for continued refusal. So the situation must be assessed from the reasonable person standard, taking into account relevant and available information, the employee's training and experience, and exercising good faith judgment in doing that. Additionally, there must be more than just a mere risk. The regulations are clear that an undue hazard is required. And so this means that the work would have to expose the employee to an excessive or an unwarranted risk of contracting COVID-19 with an absence of adequate controls in place to protect them from exposure. As mentioned, employers need to consider the work refusal on a case-by-case basis, so the employee's particular circumstances must be taken into account, and that would include any underlying conditions that puts them at increased risk in relation to COVID-19. So employers should investigate the employee's concerns and why he or she believes the protections that you have in place are insufficient. Ideally, the employee's concerns can be resolved by explaining the current protections in place. In some cases, perhaps you might amend or add some protections, and that might be sufficient to resolve the concerns. But if the employee's concerns relate to a protected characteristic under the Human Rights Code, such as a medical condition or a disability that makes them particularly susceptible or vulnerable to COVID-19, then there is a duty to accommodate up to the point of undue hardship. And so accommodation will depend on the facts, but it could include additional protections in place for that worker in particular, temporary adjustments to their job, or working from home if that's at all possible. If sufficient protections are in place to minimize risks and meet occupational health and safety obligations, and there aren't any issues related to requiring accommodation under human rights legislation, then an employee's continued refusal to return to the workplace at that point is a failure to follow reasonable instructions and report to work. And at that point, it becomes a disciplinary matter. Before imposing discipline, it would be best to well document in writing the discussions that you've had with the employee regarding their concerns, all of the measures that you have in place to minimize and reduce risks, because the employee could go to WorkSafe BC and ask to have their concerns investigated. And if that happens, you want to be able to show WorkSafe BC documentation about how you responded appropriately to their concerns, addressed them, and are able to satisfy the investigator that the workplace is in fact safe and the risks have been addressed. Sometimes the employee's concerns may not relate necessarily to the actual workplace, but other issues that are outside the control as an employer. So for example, taking public transit to work. And so again, if after considering the reasons for the concerns and assuming a protected characteristic isn't triggered, then the employee unreasonably refuses to continue to return to work, then again, it may be treated as a disciplinary matter, potentially up to the point of termination. But just a word of caution, given these unprecedented circumstances and the possibility that a court or an adjudicator may be sympathetic to an employee that's concerned about their safety, whether or not that's reasonably held concern or not. A more risk-averse course of action would be to just put them on an unpaid leave of absence until things settle down. Turning to the last question, sort of leads into, well, what if employees are not following COVID-19 safety protocols that you have in place? So as an employer, you have the ability, of course, to implement reasonable policies and procedures which employees must follow. And more importantly, though, employers are obligated to ensure a safe and healthy workplace. And employees also must follow safe work procedures. So if an employee is refusing to follow COVID-19 protocols, it should be treated as a disciplinary matter. You need to ensure that they've received proper training and they're aware of the procedures and protocols. And if they still refuse to follow the procedures, then the nature of the discipline will depend on the nature of the refusal or the breach of the safety protocols. And so a contextual approach should be applied to that discipline. If the breach is relatively minor, or, a warning or coaching would usually be appropriate. Jumping to something more drastic, such as a suspension or a termination for something that's relatively minor would likely not be upheld by a court. So again, sort of circling back to the beginning, nothing has changed in the law here. It's really a matter of applying existing legal framework to these new circumstances. So at the end of the day, an employee's failure to follow COVID-19 protocols is not materially different than an employee failing to follow other occupational health and safety protocols, such as the requirement to wear fall protection or lock out machinery and those types of things. And so it should be dealt with in a similar manner. I'll turn it back to you, Scott.
Thank you very much, Jeff. We've got time for another 2 or 3 questions, and we may go over a little bit, so we apologize to those on the line. The next question is for Taylor. Can I get employees to consent or waive requirements if certain measures are not possible, like ensuring physical distancing? Taylor?
Thanks, Scott. I'll be quick because more of the time, not because it's not an important question. The short answer is that employees can't waive any statutory requirements, including requirements of the provincial health officer or occupational health and safety or workers' comp obligations or rights. So any waiver would likely it's not going to be enforceable against the employee. So, and employees can't be asked to cover business costs and things like that. But I would say to keep in mind that pyramid that Jeff was talking about, to say if there is one measure that can't be met, there's it's flexible in that you can implement another. So if you can't do social distancing, you can maybe move on to personal protective equipment or something like that. And the thing to keep in mind is there has to be an elevated risk in your workplace that the employee got COVID there for it to fall under to be a compensable injury. So if you're taking all those steps, if the employee gets it at work and you're taking all the steps, they have to claim through Workspace. But the other thing I think that's important to think about is that messaging to employees. If they're coming back and you're saying, well, please waive or indemnify me for any kind of harm that befalls you, you wouldn't see that for any other ordinary workplace hazard, like Jeff talked about it. This is another workplace hazard like falling or non-lockout. So thinking about that and also focusing on the fact that employees have obligations under the health and safety legislation as well, with respect to there being a safe workplace and making sure that they're performing their tasks safely. So that might be another way to approach that same issue about safety in the workplace and also discipline issues that Jeff talked about. But generally, you can't consent or waive around those statutory requirements.
Thank you, Taylor. We've got one last question for Eleni. The question is, Eleni, what do I do if there is an outbreak in the workplace, which is what we're all trying to avoid, of course?
Right, thanks, Scott. So, there's guidance about the practical things that you should do if there's a workplace exposure, and that ties back into your health and safety plan, your COVID-19 plan. You'll do probably a deep cleaning, you'll increase sanitation even more to make sure that the workplace is clean, and you'll reset it back to sort of safe metrics, ensuring that, if you've had certain measures in place as part of your safety plan, you should evaluate them. Did they work? Did they fail? What was the sort of cause of the exposure? The more, and that is going to be a lot of just practical judgment of, do we need to increase some of our processes and procedures? Do we have to put up some plexiglass to avoid future exposure? And those measures should be done and should be taken in tandem with what you decide to do about notification. And notification is much more complicated because there's no actual law that requires you to notify the workplace or the public that there's been a COVID-19 exposure in your workplace. You may have an obligation to report a workplace injury to WorkSafe. It's a best practice to report to your local public health authority. But what should you do in terms of communicating with potentially your customers and the public, and specifically your employees? And I would say that all of our clients so far that have had this issue come up in the workplace have been notifying, have been transparent. I think it's been for the better of their business. You don't want the appearance of a cover-up if the media were to find out that your business had a COVID-19 outbreak and you didn't tell anyone. I'll give you the example of Superstore on Grandview and Rupert. They did a press release that they had a positive case amongst their employees. And part of that press release was all the steps they took to make sure that the grocery store was clean and safe for everybody to come back. And I can tell you, as someone that shops there, the lineups are as long as they usually have been. So I think transparency is a best practice. You also want to think about your workers and their morale and how you will continue to have employee loyalty. If someone tests positive for COVID-19, the public health authority does engage with them to do the contact tracing and to contact people that may also have been exposed. And do you want your employees to find out from a third party who's going to be very clinical with them and potentially scare them more than they need to be scared, and potentially cause them a lot of upset, or do you want to be sort of first there and call your person and say, you know, I wanted to tell you that we have this workplace exposure, you know, we think you might be impacted, here's what we know, here's what we don't know, and have that kind of relationship with your employees. And I think generally speaking, we want to be that type of employer and not the type of employer that doesn't actually engage with its workforce when there's an issue at play. So we do recommend transparency, and we should not confuse, though, transparency with disclosure of a diagnosed person's identity, for example. So that will tie back into privacy law principles and need to know. There will be people within the business that need to know who was exposed and what the facts are. Others within the business will only need to know that there was an exposure and what steps the employer is taking to ensure a safe workplace and rectify the situation. So you have to keep in mind that if someone's diagnosed with COVID-19, that is personal information, and you may need their consent to disclose it to others. If you want to do a disclosure beyond the need to know standard under privacy laws. But overall, you know, if you have an outbreak, you'll do all the practical things that you need to do to create stability in your workplace, and how you should notify and to what extent should be part of that discussion.
Thank you, Eleni. And this draws to a conclusion of our seminar today. I want to thank you all for taking the time to call in. As we indicated at the outset, feel free to reach out to any one of us, any of the panelists, for further questions on specific issues. This has been fairly high level in some areas and detailed in others. A great resource that you may not be aware of is online. You might check it out on the slide. If you can move the slide to the next one, it's the COVID-19 Labor and Employment Hub that's found on Dentons.com. It's good content. It's developed constantly. We've actually focused specifically on giving you information you need to track your responsibilities as an employer on. It even covers 63 markets. So it's quite a wealth of information. So we encourage you to take a look at that. And I wish you all a happy and healthy weekend. I always premise that by saying all considered. So stay well and please check in, and we thank you again for participating. This ends the seminar for today. Thank you again.